Hi, everyone. Welcome. My name is Jackie Gharapour Wernz, and we're excited to have you here today for our second discussion of the many rapid legal developments facing schools as we respond to COVID-19. For those of you who aren't familiar, Franczek is a boutique law firm in Chicago. We focus on education, labor, and employment law, and we represent educational institutions across the state of Illinois on the full range of education issues they face. By way of a little bit of housekeeping, there is a way to type questions. We can't promise that we're going to be able to get to all of your questions because we've received so many before the webinar, but we are going to try to get to as many things as we can in this next hour. We will be posting a copy of this webinar recording after the fact so that you can share it or review it again if you'd like to see our smiling faces one more time. So with that, let's jump in. And you can see everyone on our team who's here today. In the top left corner, we have Jennifer Smith, and then below her is Nicki Bazer. To her right is Fattore Crumley, and at the bottom of our screen is Shelli Anderson. So everyone can say hi, and we'll just jump right in. We're going to start out with some general questions. So first of all, Shelli, can you explain to us the implications? Where are we with the stay-at-home order right now?
Sure. So I think as everyone remembers, shortly after our last webinar last Friday, which seems like forever ago now, the governor entered into the stay-at-home order, which in effect said that all schools had to be closed through the 7th, so extending the order from where it was before. I think that what caused some confusion as to how schools were going to continue to operate, and educational institutions, including K through 12, were specifically exempted from the stay-at-home order to the extent that they needed to stay open for facilitating remote learning or for other essential functions, which in effect means that in terms of the district determining who is going to be an essential employee who needs to come in, and that, I think we're going to talk about that a little bit later in other questions, but that is still permissible even though the school itself is closed for student instruction, that the business of the school still has to go on, and that was expressly recognized by the governor in the executive order.
Now, Jennifer, how does a district determine which employees have to report to work to perform essential functions?
So this is, first of all, going to be determined by the district and depend on what your plan is for continuing functions. So you got to look at what are your functions that are continuing and who do you actually need to be at the school to continue. So this will vary because different districts are providing widely different services. So for example, if your plan is to do remote learning through packets, obviously for printing reasons, that might require more people to be in your building. In that case, we are reminding people to be thoughtful about maybe making shifts or schedules to reduce the amount of exposure your employees have. But the bottom line is schools determine who's essential and who needs to come in.
Do essential employees need any sort of travel papers or certification showing that they are an essential employee going to work?
That was something that we've really heard a lot of questions about, and I know that there was some model certifications going around from a number of different school districts, and the answer to that is no, that they're not needed. The executive order did not indicate that that was going to be required, and I think the governor's actually come out a few different times and specifically said that he does not expect the police to be enforcing this. That being said, we've heard of a few isolated instances of people being stopped by, maybe overzealous police wanting to make sure that we're all kind of staying at home to flatten the curve, and asking for some sort of certification paper. So it's not necessary. If your employees are concerned about it, though, it certainly is something that you could provide them, or perhaps they have their school ID. But if you take this a step further, the executive order also allows for travel to go to the grocery store or to go to other outdoor activities. So it really does not make sense there be any sort of certification required at this time under the terms of the current executive order.
Great. So we've actually got a question that segues us really nicely into our next part of our discussion, which is about Act of God days. So if schools are closed through April 7th, are these also Act of God days? Where are we on that, Nicki? Can you give us insight into what ISBE's thinking or where they're going?
So good afternoon, everybody. And
We have no formal confirmation from ISBE yet. We are expecting guidance, hopefully today, potentially early next week. But at this point, our understanding is that going forward, we will see instructional days rather than active God days. So what that looks like, I think there's going to be a lot of flexibility for school districts, understanding that everybody's at a different point when it comes to providing remote learning, e-learning, but we do expect a shift from ISBE away from active God to instructional or remote learning days. But again, waiting to see that ISBE guidance to confirm for sure.
Okay, and then if they will be instructional days, have there been other changes related to e-learning programs?
Jackie, I can take that. You know, and March 23rd, the governor entered another executive order, and this one specifically spoke to the issue of e-learning and how schools could go about adopting those programs who had not done so yet. And it really made it much more flexible process that the board does not have to formally adopt it anymore, that it doesn't have to be a public hearing or the communication period of 30 days for staff and students before implementation. That being said, the ROEs still do need to approve them. I think there's going to be a lot of flexibility around what that looks like. You know, it doesn't have to be 5 instructional hours anymore, and they really are, I think, trying to make it such that all districts are able to some way provide for the substantial learning, and that's really the language that they focus on during the school day so they can count towards the instructional day.
Okay. So it's our understanding that ISBE will be issuing extensive guidance around distance learning and that it's going to allow for that max flexibility. What do we need to know about using video conferencing, for instance, or some of the other things that we're going to come into play with that flexibility?
Yeah, absolutely. And obviously we're doing this webinar via Zoom, which is a first for us, and we're really excited. We fully expect that one of our pets or children will be seen or heard through this process. And I know everybody is experiencing the same thing at home. But we have gotten a lot of really good questions about what we need to know related to the use of video conferencing. So privacy concerns, platform concerns. I think, you know, one of what we're saying at this point and what we're advising is that we understand that teachers and districts want to use these platforms to reach out. We want to be able to see our kids, to interact with them, engage with them. I may have mentioned this in the last one, but one of my shout out to District 65, my daughter's teacher jumped on a Zoom call with the kids, and that just sort of made a world of difference in terms of connectiveness. But we do want to be smart about this. We do want to keep in mind student privacy concerns, data concerns. So, you know, a lot of you all already have these tools at your disposal. So you're using Google Hangouts or other programs like that through platforms that you already have, through agreements that you already have with a technology vendor. In those cases, go ahead and keep using those. If you have a strong vendor agreement, that's wonderful, that has data security and privacy considerations already in it, that's sort of the ideal. And then in those cases, we think, you know, passive consent from parents is sufficient. So just sending out notice, hey, just as you know, we use Google Suites for education. Part of that is this platform that allows us to interact. We're going to have our teachers using that, and that's what's going to happen going forward. If you don't have a data privacy agreement with the vendors that you're using, we definitely encourage you. We have a data addendum that we recommend districts use for any situation where you're using a technology vendor. So absolutely, attaching those to contracts, negotiating those now is a great idea. Again, using Zoom for education. We have taken a look at their privacy policy. We feel pretty comfortable with it. Again, our data addendum would be belts and suspenders, but if you're using Zoom for education, you can feel fairly confident that they have good privacy protections. I think really where the concerns will come in is if you're using a basic platform, so you're using Zoom Basic or something like that, which you're just getting free online. Those that are not specifically geared towards K-12 purposes, we really would caution because there could be some significant privacy concerns. For those elementary districts out there in particular, if you have students under the age of 13 using them, you also then have COPPA concerns. And we'll go through those at another time in terms of the details of all those laws, but suffice it to say that you will need to get parental consent for using those, particularly when you're dealing with students under the age of 13. So again, If you're using an education platform that you already have a data agreement with, or you're using Zoom for Education, notifying parents that you're using them, always a good idea. If you're using basic platforms like Zoom Basic, then I would go for a full parental consent, and we're certainly happy to help you draft those and make sure that you've got all the protections and that parents know what's happening in those kinds of video conferencing.
Now, Dana, I know you and I have been talking a lot this week about recording and Zoom and what are the rules around that. So tell us, what should schools be recording any teacher instruction, any one-to-one service sessions, anything of that sort?
So I think recording raises some unique concerns, and we've had all kinds of questions on this. I mean, certainly we've had districts share questions from teachers who are very reluctant to be recorded. And I will say we all had a little exchange before this, how we're so used to public speaking as teachers are, but being recorded and being on video is very much a different experience. So we have to have some empathy for that. So I mean, I think the first thing to think about when you're considering recording is you really need consent to record. And many of the teachers unions have already been reticent about recording. They may not want you to record. Whenever you're recording anything that's educationally related to education, you also have to have student record concerns. So FERPA, ISRA, we are creating a record if there are students on so when you're talking about an all-class Zoom class, and my daughter actually had a class like this yesterday through University of Illinois, where all the students and all the participants in the class could see each other. Their comments were being heard by everyone. The teachers' comments were being shared and heard by everyone. If that was recorded, that would be a student record. I think to record those kinds of lessons in the K through 12 setting, where we have parents making record requests, and especially I'm thinking of Jennifer in the special ed due process context, if we had to store and produce the geometry class that took place March 25th at 10:30 a.m., that would become just an administrative nightmare. So I think our general advice is to refrain from recording of whole group lessons that you would use on that you would do on Google or Zoom. As far as teachers, I think can still record themselves, just themselves, like you would do for a flipped classroom, and put that and record that. But again, they would do that at their own choice. That would, if there's no other students on it, it's just the teacher, that would likely not be an educational record and you wouldn't have the same concerns. The other big area where we're getting questions about recording is one-to-one service sessions. So either one-to-one instruction between a teacher and a student, or one-to-one related service provision between a teacher and a student. So speech therapy, social work, those types of activities. Do we want to record those just to prevent liability, so that if someone has a question about what happened later, we can show the tape and say, this is what happened, you can view it. And I think, again, the people involved in that need to consent to recording. I think that when you're talking about older students who are receiving services like social work, I think that the recording probably raises more questions and concerns than it would help you prevent liability. Again, we're recommending for all of these types of services that you do some sort of passive consent, and you explain to parents that we're going to be providing this service. We do it all the time at school. We understand the context is different because we're coming into your home, and your home is more of a private setting that you're not used to having others come into in this way, perhaps. So if you have any concerns with it, let us know and we'll discuss alternate means to do the service. And that, as long as you're putting that disclaimer, that sort of passive consent out there, you can go ahead and have the session and not be concerned about recording, because again, the confidentiality determinations to be made after that recording is retained are complex, and we should probably avoid them.
Unmuting myself. We did get a couple of questions on the chat function, so I want to throw those out, and I think these are good ones for Nicki. So one of them is, what are the recommended platforms for teachers and counselors to communicate with students when they need to provide check-ins and additional supports?
Sure. Again, it's the same. I think it's the same answer that we were talking about before. So if you're using a technology platform that's specifically designed for education and for which you have a vendor contract, so that addresses student privacy concerns. So again, if you're using Google Suites for Education, that's not exactly the right name for it, but if you're using Google and you have a vendor agreement and you're using a platform through Google, that's specifically designed for the K-12 purpose, or something like Zoom for Education, those would be the same answers that we would use for special education services as well. I know there's been a lot of questions about some being HIPAA compliant. You know, we do actually have an attorney from one of our law firms in another part of the country asking that of the federal U.S. Department of Education about, you know, using HIPAA compliant platforms. So if there is an answer from the U.S. Department of Education, we will definitely update you. We generally don't consider, you know, HIPAA is not generally applicable in the K-12 environment. And so the fact that something is HIPAA compliant doesn't necessarily translate that it's FERPA compliant or student compliant. But it's a good metric that, you know, if something is safe to use under HIPAA. So we'll await that answer from the US DOE. In the meantime, you know, again, if you're using a platform that you have a vendor agreement with that's specifically designed for educational purposes and contains those protections, those should be acceptable also for the provision of special education services like social work or one-on-one services in that way.
And Nicki, just to follow up on that, what we don't want is people just letting teachers just find any app that they want to find on their phones or by a search or having their next door neighbor tell them or whatever. We want them to go through the district. And even if if it is a free platform, there's still some protections that you can put into place to make that viable for this period.
Absolutely. That's such a great point, Dana. And I think, you know, and we realizing that we are in a completely different universe now, we do want to still try to use the processes and procedures that we have in place. And so if it's typical for your teachers to go through a vetting process to use an app, and they, you know, that goes through your IT folks, or your curriculum folks, and you have an approved list versus not, keep using those processes. Like, we know that people want to grab onto technology in a time like this, but we want to do it in a smart way. And so have your teachers run that through the typical process is the best way to go.
Now, what about flexibility and student privacy issues for special ed services being provided to kids in small groups or individually? Nicki, do you want to take that one too?
Yeah, again, I think it's the same answer, you know, in terms of, you know, what we're wanting to do is make sure you're using a safe platform, make sure that parents are aware of what you're doing. Again, you know, at the younger grades, or if it's consistent with sort of the way that your district handles things, maybe parental consent is an important issue. We can talk with you about your specific individual needs. But again, you know, using those safe platforms, notifying parents, getting consent when needed, I think are the right ways to go for gen ed students and for special education students.
Okay. Now, Dana, what about parents recording teacher instruction? Any thoughts on that?
So we've definitely had some questions about this. I think teachers are very hesitant to be recorded. And I think of all the districts that I've worked with that put things into place that don't let parents choose the teacher, you know, they don't let parents know who the teacher is until right before, so there's no conflict about which teacher they get. And I'm thinking that some of this is going to undo all that pretty much instantaneously, because they're going to be able to see what the different teachers are doing. So, but I do think that you need to look at your policies that are in place in terms of recording the classroom, you know, taking pictures, taking photographs. You know, certainly there's a distinction between just a regular day of instruction. We don't have people coming in. We don't have people posing for photos. We don't have students or parents recording the lesson. And I think that general guidance applies here. We've drafted some language for a few clients that basically says, you know, here's our policy when school is in session normally. Here's our policy now. We don't want you recording the lesson. We don't want you posting the lesson on Facebook. We want you to treat it just as any other lesson. If there's something that you want to take a picture of, or that you want to ask permission to use in some way, then you would do that by contacting the teacher, contacting an administrator, and going through that channel.
If I could just add one thing here, Jackie, and I don't think it's always for a negative intent that these families may have. I think some families are taking pictures of their kids learning with their teachers as such a positive example and then posting it to say, look at how amazing our district is and my connection that my student is having with their teacher. But even that, from the teacher's perspective, can feel a little invasive. So, being mindful of everyone, I think, here has the right intentions, but just being sure that we're respecting everyone's privacy when we have teachers now being available to be seen by families, as well as, families now having the teachers and all those, kids in their homes through these platforms as well.
Yeah, that's so important. I mean, it's completely different when you're a teacher and you're running a spelling bee at school. You expect all those proud parents to be taking pictures. But when you're doing a lesson and it's online, you don't have that same expectation.
That makes sense. Now, we know some kids don't have the devices that they need in order to engage in this kind of instruction. So what policy modifications should we look at for sending Chromebooks or other technology home with students?
Yeah, absolutely. And a huge shout out to the districts that are getting technology in the hands of students. I'll shout out to one of my pals over at Itasca 10, who I think the superintendent, the CSBO, the principals were all handing out Chromebooks in the parking lot. I mean, you guys are amazing and you're doing great work out there. You should look at your acceptable use policy and see if it's broad enough. If you don't have one-to-one, we can certainly add to the policy. I think consent forms are great. A lot of times a district, high school districts that are used to doing one-to-one already have the consent form. A lot of elementary districts have it for their middle school, but maybe not for their elementary. Easily adaptable. Or if this is something completely new to your district, one-page sort of consent form, we're happy to work through that with you. Just sort of the do's and don'ts with an iPad or a Chromebook. And just identifying for parents, what they need to be watching out for, what filtering you're providing, obviously that they're sort of also should keep an eye on what the students are doing on their Chromebooks, and then signing off on the consent. Certainly the consent right now can be electronic. If you have processes to do that with your parents, absolutely. I got a really interesting question about whether you should have like a first grader sign the consent form. Usually we don't have kids that young sign consent forms, but absolutely a consent, that parents sign, and also that they sign that they've gone through it with their kiddos, and that the kids understand the rules. Just honestly, like if you can get some technology into the hands of your kids, do so, and we can get the right forms in place to make sure that works for you.
Now, we obviously hope this doesn't happen, but let's say that there is some misconduct, either using technology or in some other way. Jen, what can we do? Can we impose a suspension or expulsion during remote learning days? What options are available?
Sure. So both the state discipline code and district policies on discipline are certainly broad enough to cover any misconduct that happens during remote or distance learning or impacts remote or distance learning. So are you going to suspend or expel? I'm sort of waiting to see how severe the behavior is. I mean, obviously we can all tell a lot of stories about things we've seen happen in schools that, you wouldn't think would necessarily happen. So I'm not naive enough to think everyone's going to behave now that they're home in a way that doesn't interfere with learning. So we'll see what happens. This has not been a major issue yet, but yes, you absolutely do have discipline tools available if things go awry.
Okay, so switching gears a little, ISBE question. Nicki, as our former general counsel for ISBE, can you tell us what waivers have been issued? What do we need to know right now?
Sure, and kudos to ISBE for all the work they're doing. I know that it's hard to be in that position right now. So what we have gotten word from, and those of you who are receiving the information from the state superintendent, who's been wonderful and very communicative, has alerted everybody to this, but I think they're important to note. It appears that we will be getting waivers for all federally required assessments for this school year, so the IAR, the state mandated testing. It appears we'll also get the waiver for the requirement to provide summative designations and identifying schools for targeted and comprehensive supports. So the school designations and also the accountability indicators on the report card. So, so far, I think, those are good news for districts. It just takes one more thing off of your plate while you're trying to navigate everything else right now. So.
So we've already put deposits down for end of the year activities like prom. If those are canceled, do schools have any recourse in getting their deposits back? Shelli?
Jackie, I can take that one. I think, really the first place you need to look at is in the contract itself. And some of the contracts will have specific language that talks about if the event of the, event not being able to go forward for a particular reason or reason outside of the district's control, that there's some sort of arrangement that's made, whether it's getting the money back or whether it's being scheduled for another time. I think that if the contract itself doesn't say that, I think it's definitely worth reaching out or having your attorneys reach out to the vendor's attorneys to talk about what other arrangements can be made. I know that in District 65, where I am too, unfortunately, my son's supposed to be in Washington with his 8th grade trip over spring break, and that had to be canceled. And so working both with the vendor company that was supposed to be taking them to try to either come up with another date or to see about getting any sort of refunds to parents. I'm just hopeful, for so many of our seniors out there that in some way that, prom or graduation can still go forward. So looking to try to think as smart forward as we can, but not maybe outright canceling things just yet, being a little hopeful there.
Makes sense. All right, let's talk about board meetings. So for those of you who receive our firm alerts, you would have seen our alert a couple of days ago about the resolutions that we've seen floating around giving superintendents greater authority. Shelli, can you tell us what's happening there?
Yeah, so there were a few different resolutions going around, and I think the Illinois Association of School Boards had put out a sample, and I think there was some misunderstanding when they put it out, and they later put out a message, I think, to all of their members about the reason for putting it out. And the intent was for it to start a conversation between the superintendent and the board and council about what might be needed in a particular district with respect to giving the superintendent broader authority during a time of crisis to take quick action. That might be needed in certain districts for certain reasons, but in others, you may already have enough authority in the superintendent depending upon what your existing policies are. And you may also have boards who really want to still be involved. And with the ability to do virtual meetings, things of that nature, I'm not sure, we're certainly not recommending that this be adopted across every district. And the state board came out and said, or the Illinois Association of School Boards, came out and said that that was not their intention in putting that sample out either. So I would just recommend that if there's a reason your district wants it, to make sure you follow up with your council to talk about the specifics of what that looks like.
And you mentioned those virtual meetings. Are boards going to continue to be allowed to meet virtually without a physical quorum?
Yeah, I mean, the governor executive order really relaxed the standards around what's required. I think that was so important for our board members to not feel like they had to be compelled to be in an area when they're volunteering their time and so much of their time to then put themselves at risk to have to be in a public area with the other board members as well as the public. So that relaxation around the rules, I think, was really vital. And I think different districts are figuring out how to do it differently, whether it's through a YouTube channel or some other sort of way that they're making it available to the public. We have actually drafted legislation at Franczek that we're going to be, if the General Assembly comes back, codifying what the governor did with respect to not requiring a physical presence there, to make sure that any action that was taken during this time period, that there's no question that that is all kind of valid legal action that the board had taken, even if they weren't all there together in the same room. So we'll just wait and see on that. But I think it's an important step that we have to take.
Great. All right, switching gears a little, let's talk about special education. So our first question there is, in a scenario where we move to e-learning instructional days after March 30th, so not active God days, would IEP meetings be required to specifically address the unique special education situation presented by remote learning? Jennifer, what do you think about that?
So we do not think that IEP meetings are going to be automatically required. This is an area where there's significant disagreement across the country, and I'm not saying that we have crystal clear guidance, but I think the better guidance and the better practices from different states are, this is a methodology change that doesn't automatically require an IEP meeting for every IEP student in the state. Not only is, I think, that's the better legal analysis, but it would be logistically, I don't even know if it's possible. So we're not recommending that. What we do think is a good practice is for case managers to touch base with parents and perhaps provide draft something like a one-pager that confirms which goals are going to be worked on remotely and which services will be provided remotely. Some districts are calling this a remote learning plan. And then it's just a remote learning plan, so it's just going to be in place during the time of distance learning, and confirm that's part of the IEP by doing an IEP amendment. That's where the parent agrees. If you did this process, we're really mitigating against massive comp ed claims or claims that you're not implementing the IEP. So to the extent all of this, many, as with most things in special education, 99% of parents are going to be agreeable and reasonable and say, yes, of course, we're not going to work on this PT goal that requires a person to be present. That's not possible right now. So we agree we're going to only focus on these other areas.
Now, what if a parent opts out of special education services? What do you think about that, Dana?
So if a parent chooses that they for whatever reason, that they're just not comfortable having certain special ed services in the home, then I think let them make that choice and document it by issuing a withdrawal form that you have made the decision to withdraw from special ed. You won't be getting the instruction that's going to be part of the IEP, but you can still participate in the district's general e-learning program, whatever that looks like. But you do want to document that. And again, not to be, I think you need to discuss it with them and not to close off students from services that they need, but it's also, we're sort of in a triage mode, and to really argue with people that don't want something, I don't know that that's a good use of anyone's resources right now. So
we've got a lot of questions about minutes, missed minutes, keeping track of minutes. Do we need to keep track of minutes missed and provide compensatory education? What do we think?
I do think the better practice is to keep track of the services that you're offering. So you're going to keep track of a couple things. The services that you're offering, I do think in some form or fashion, we'll be better off if we track student attendance, because think about normal student days. If the student's gone and misses related services just because they're absent, we don't do comp ed for that. So I would like to have the argument, again, if families are opting out and withdrawing or just not engaging, it's not because we didn't make it available. And I think it's possible that will make a difference on the backside. So it would be nice to track student attendance. Now, that's different from regular ed because obviously, or at least up till now, we'll see what the new guidance is, you didn't have to track attendance. So we have gotten some pushback from special ed teachers saying, wait, but my gen ed teachers, they're not tracking attendance right now. Again, it's because we're tracking what services were available and looking to the future of how are we ultimately going to maybe decide comp ed. We don't know that formula, but if we don't have those pieces of data, we can't even make the argument that the reason the services weren't provided is because the family decided not to make the student available. So I think we do want a mechanism to track both of those. Ultimately, comp ed, we don't know yet what the calculation is going to be and whether it's going to be some sort of quantitative, this many services were owed, this many were provided, so you owe this many on the back end. I'm not necessarily sure that's going to happen. It might be a more qualitative, what does the student need after this experience? But we can only benefit by having that information so that all arguments are possible at the end.
Okay. We received a question about if you have a student in a private therapeutic placement who has to move to a new placement in another district, who picks up the cost of the bill during these out of schools?
So this is the same as if we were in school normally. Special ed residency is under a separate section of the school code. And once a student moves and changes residence, the district where they reside is responsible for providing the program. So in this scenario, the new school district would be picking up the cost of the therapeutic day program.
Now, Jennifer, you may have mentioned this when you were talking before about PT, but what if goals can't be addressed in the home setting, like physical therapy?
So a couple things. One, obviously, do not send people into the home right now. This is not the thing to prioritize. We are triaging. I'm involved in a small group of Council of School Attorneys that works part of National School Board Association. We've drafted a legislative fix as far as seeking in one of these different bills that they're doing at the federal level to put in language to waive school districts' requirement when in-person services are required and they would not be safe to provide, which we think applies right now. Now, you know, your guess is good as mine. That lobbying effort, I don't know whether it will be successful, but that I think is a very reasonable position to take. My other suggestion about doing an amendment for a remote learning plan where the parent agrees that certain services would not be required during this time, that's going to mitigate against, you know, arguments that we should be providing services that we can't. And then, but at the end of the day, if the parent won't agree to take something out, I mean, you can have an IEP meeting and the IEP team decides this is not a reasonable service right now. It's not appropriate for the student. It would put their health at risk, so it's not an appropriate service, and so we're removing it from the IEP. We can absolutely do that as a team. You can't, keep in mind, amendments are when parent agrees. IEP meetings is if you have to discuss something where the parent's not in agreement.
Okay.
Yeah.
What are considerations for remote evaluations or evaluations that are difficult to complete remotely? Dana?
So obviously there are certain students and certain types of evaluation tools and instruments that it's not going to be practical to do those in an online setting. And I think we need to go back to the initial ISBE guidance from on special ed and on timelines. While the timelines are not completely relaxed, during these Act of God days, you're not in school, it's not a school day, so those are not counting against you for evaluation purposes. They're not part of that 60-day timeline. So that gives you a little extra time. I think to the extent that we go back to we're out of Act of God days and we're back to instructional days, then we're going to be back in the situation where we do have to look at timelines and make timelines. And I think the answer is you're just going to have these conversations with parents and make an educated decision based on the related service provider, based on the guidance from your psychologist as to what is feasible to do and how to best proceed. And it's not going to be perfect, and you may need to revisit it later, but that's really the only thing that we can do under these circumstances. And I think if you convey that to parents in a way that, you know, transmits the importance of the student's educational needs, but also balances that with the severity of the crisis that we're all facing right now. And we have to do things in order. Sometimes we can't do things all at once. So maybe the health, going back to what Jennifer said, which I think was so important, is IEP teams need to meet in these situations if parents aren't in agreement, and we need to have a discussion on the record about the health and the safety of the student is the top goal. Whether they meet their goal or whether we finish this evaluation about what their processing speed is a secondary goal. And we can look at that goal when circumstances permit. We're going to keep doing everything that we can to make sure the student is receiving something that's meaningful and provides benefit, but we might have to put some of these things on pause.
So we've had a few questions about summer. I mean, if the weeks keep going by as quickly as they are, summer is going to be here before we know it. So as we are out of school longer and annual reviews are held, do you have any suggestions about how teams should navigate the ESY conversation? Jennifer?
Sure. So the legal standard, we're using the same legal standard, which is consider the student's ability to, or regression, their ability to recoup after, and also critical skills, whether they're missing a critical skill window for building a skill such as reading. They're in a critical period where reading booms and the lack of instruction is going to be detrimental. I think that the critical skills test in these circumstances might end up, we might getting more students eligible than would have otherwise because they're missing instruction and they might need some summer instruction to work on a critical skill. But we shouldn't assume that summer ESY instruction is in person, and summer instruction is to maintain, not necessarily to accelerate skills. So you're going to use your same standards, but we're going to take into consideration all the circumstances right now, which is ESY may not be in person, and but more students may require it because of the circumstances we're all in.
Okay, so switching gears again, let's talk about employee issues. And first off, leave and benefit issues. We continue to receive questions around employee leaves during the school closure. So for instance, if someone is on sick leave or unpaid leave, do those days stop during the Act of God days or after March 30th?
Jackie, I think we touched on this a little bit in the last webinar we did last week, but we continue to get these questions, and I think they're going to continue to come because every circumstance that arises is a little bit different. I think that the important thing for school districts to remember is that the guidance that's come out from ISBE, and I have every reason to believe that it's going to continue beyond the 30th, is that employees have to continue to get paid as if the school were normally functioning. So if, for instance, you were having your employees perform some work, and because an employee is unable to do that work and they're on sick leave and they continue to be unable to do that work, then that benefit day still counts. That sick day should still be counted if they're unable to do what the other employees are doing. Now, that might be different for those districts out there that currently do not have work for all of their employees to be doing. And in that circumstance, it's my recommendation that you would not necessarily count that day. But again, I think it's really fact specific, and we have to look at what the district is having the employees do and what the individual is able to actually perform. And was it just sick leave because they couldn't come to the actual building? And that's what I think will make the difference. And I think it'll be very different after the 30th, because if we start considering those instructional days, to the extent that employees were expected to perform some work before, all those districts out there that did not have any sort of distance learning program are now going to be putting things in place. So there'll be a much broader expectation of all employees performing some sort of work. And the districts having to look at, if someone is unable to perform that work, looking behind the why and then figuring out how that day should be counted for them.
Now, for those employees who can't come to work due to a health condition, do they have to take benefit days?
I would say, again, that depends on why they can't come to work, and it depends on what you're expecting your other employees to do. So I think the idea of kind of coming to work, that whole concept has changed now as to what that looks like. So I think that if they cannot perform the work you're expecting them to perform, then they need to take a benefit day. Or if they don't want to come to work and they happen to have a 12-month employee and they have vacation time, taking a vacation day because they're not going to do the work that's being asked of them to do.
All right, we received a scenario question. So what if you have a teacher who's already on unpaid FMLA leave, but now they want to come back because they can do e-learning from home, and the district already has a long-term leave sub working? What do you do?
Sure, I'm happy to talk about that. I think we touched on this again a little bit during our last webinar. So you cannot require someone either to take FMLA or to stop. If an employee wants to stop the leave and either provides doctor certification that they can work, or they have a condition, we know how difficult it is for people to get into doctors these days. So if they have a condition that would lend itself to return, so for example, I think I mentioned, if they had knee surgery and they can't physically get into a school building but could provide remote learning, or the thing that we're seeing obviously a huge number is maternity leaves. So if, after 4 weeks a teacher wants to return rather than 6 weeks or 8 weeks, and I don't know that you'll need to get doctor certification for that. Again, case by case, there may be some conditions, mental health conditions in particular, where you're going to want to see that doctor for certification. But absolutely, if a teacher does believe that they can return, that's something that they should be allowed to do. Again, specific circumstances notwithstanding. In terms of the long-term substitutes, you will continue to need to pay them through the duration of the substitute term that you had contracted with them at the beginning. So if originally they were going to cover for a teacher who was out on maternity leave through April 30th, now that teacher is returning, you're still going to have to pay that long-term sub through April 30th. Certainly encourage you to keep them working if there's some assistance that they can provide to supplement or augment the remote learning for either that teacher or other teachers in the grade. Absolutely utilize them, but because you will have to keep paying them. So one caveat, actually, I should just add this. Sorry, Jackie, to cut you off. Teachers should understand, though, that they can't jump on and on FMLA leave necessarily. You need to look at the specific circumstances. So, for instance, if a teacher's on leave for bonding time with a child, that can only be taken intermittently if the school district agrees. So once that teacher stops, they may not be able to resume that leave. So you should definitely, the HR folks out there who are talking with folks about returning from FMLA should just, give them the full information, and make sure that they're understanding what that leave looks like or what that return looks like.
So we've had some questions on our Q&A today about the Family First Response Act, sick leave, FMLA. I'm going to ask Shelli to tell us briefly about it, but I do want to point out that we have a ton of resources on our website. We have a recent podcast that was just issued that entirely focused on that topic. So please check out our resources there. But Shelli, can you give us a sense of what's going on with the DOL regulations? And
Sure. I mean, just at a high level, and I think, Jackie, you're right. We have so much material on our website already about this, but just, and obviously we know that it does apply to school districts, regardless of the number of employees that you have. It affords 80 hours of paid sick leave for employees, and that's on top of any other leave that your employees are already eligible for. There are caps on the amount that they can get. So it's, $500 a day, or approximately $500 a day if they're caring for, if it's because they can't come to work, and it's 2/3, and I think the cap is $200 a day if it's because they can't come to work because they're caring for someone else. And the language is not just a family member, it's you're caring for an individual who's suffering from the disease or has symptoms and unable to go to work or isn't quarantined at home. And then we also obviously have the new provisions around the FMLA, which expands it in terms of allowing someone to take leave for someone who has to care for someone because they can't go to school. And I think as the school closure is likely to continue, we're likely to see more of that, and employees coming forward and saying they need more leave time related to being able to take care of their kids who are home. The one thing that the Department of, the regulations that came out just recently, and questions we've gotten came up about this, is that it cannot be retroactive. So if you had an employee who had already needed the leave and it was taken on an unpaid basis because they didn't have any benefit time available, that they cannot now look toward the new legislation and say, well, now I need to get paid for that. So the regulations that came out did indicate that. The other big thing that came out of the regulations is that we were all under the assumption that everything was starting on April 2nd. It's actually starting on April 1st. So being mindful of that as well. And, I don't think that press has put out a policy change yet with respect to how this is going to be handled from a board policy perspective. I would say that, there are very specific guidance that's given as to kind of what the leave is going to be, who's going to be eligible for the leave and what that looks like. So just making sure that you're working with counsel, you're staying in line with kind of what those requirements are.
okay. We did get a question before the webinar through our allmarketing@franczek.com. Always feel free, if you have any topics you'd like to see us discuss in a future webinar or alert, to send that message or request there. So the question we received was that teachers who are currently on a PDP this year, since the process has not been completed, can it continue next year if we do not return, or if it's past the deadlines in the CBA agreement?
I think that, that is a question that's going to be an interesting one. I'm hopeful that the guidance that comes out from ISBE does touch a little bit on what happens to those districts who are involved in remediation plans or professional development plans with their teachers right now. You know, the difference with the question that you've asked, Jackie, is that the professional development plan piece, you know, that is typically done district by district in terms of how long that is, what that looks like, the time periods it needs to be done within. So I would say that in the specific question that you're asking is if the collective bargaining agreement says it has to be done within one school year, for instance, and it can't be now because the teacher is obviously not able to fulfill the requirements of the plan, I would say that that district should really work with union leadership around that to try to figure out kind of what that's going to look like for the teacher moving forward. The remediation plan is a little bit different because that's a very, you know, state specified in terms of how long that has to last and what that has to look like. And we're hopeful to get some guidance around that now, especially for those teachers who are currently under a plan and that has not yet concluded and would need to go necessarily into next year now.
Okay, so let's talk about some administrative things, less leave related, but some employment administration issues. So if the state ends the school year early for some reason, how do we apply the 45-day notification? Shelli?
Yeah, well, first I want to say that we have no indication that the state is actually going to be ending school years early. It looks like, by all accounts, that because these days are going to now not be considered active God days, and I say that with the full caveat that that may all change, and there actually might be something that comes out contrary to that because we just don't know what's happening. But presuming they're all instructional days, I've seen nothing to indicate that there's going to be any sort of modification of the 45-day period to give notice of honorable dismissal or non-renewal to your probationary teacher. So it's March 27th, which means that you all the districts should, at least by the first week in April, making sure that those resolutions are going out to teachers. And you know, the school code requires them by certified delivery. Certainly I think that you should still do that where possible, but then also email it to the teacher who's being affected to make sure that you have you're in place to follow those timelines that are in the school code.
Another question on the administrative side, can you require employees to do different tasks if they're different from their regular duties? Dana, what do you think about that one?
Yes, you can. I mean, obviously you want to have conversations about what it is you need people to do and what your essential functions are right now. I think we touched on that earlier in this program. But certainly anything that is related to an essential function of a school district, if you have support staff, people that are needing to report, you can ask them to do those things. I understand that people are concerned about getting resistance. I mean, you need to remember that if people have paid time off, you know, there's nothing different about this situation. If they have vacation days and they prefer not to come to school and do the tasks you're asking them to do, and they have available vacation days, they can take those vacation days as they would under your normal policies and practices.
So we talked a little last week about stipends, and just as a reminder to folks, you can hear our last week's webinar you can download it as a podcast with the caveat that things are changing very quickly. But one question that we had for this time with respect to stipends is it our understanding that pay will continue regardless of whether the activity proceeds?
At this point, I think we're waiting to see what the next round of ISBE guidance is. Our expectation is that that pay will continue regardless of whether the activity proceeds. But so that would be the assumption that we're working under right now. But again, it could change depending on what ISBE comes out with if they address stipends in their next guidance.
So Nicki, also maybe answer this one for us. Can we discipline employees who refuse to come in or to do work that they are directed to do?
Right. So, hopefully districts are not seeing widespread, but we have heard some questions about, employees who refuse to come in physically to work when they are required to, or do work remotely that they're directed to do. First of all, have a conversation with the employee. Obviously, why don't they want to come in? Or why aren't they want to do the remote work that they're being required to do? If it's an issue of, I recently had one where a food service worker was expressing some concerns related to an underlying health condition, and she was concerned about coming in physically. So then it's a conversation about what leaves or what benefit time might be appropriate to take. So if they need to be on sick leave or FMLA leave, or some other type of benefit leave, obviously after the new law kicks in as well. But if at the end of the day, they're just refusing to work or to come in, certainly you do have the option of disciplining folks for a refusal to work.
Okay. Now, what if some employees are required to come in and obviously a number of employees aren't? Are those who come in paid additionally?
Well, that's a great question, Jackie, and one we're getting from so many school districts. I have to say that my initial answer is no, that just because one group of employees might be able to work remotely and another cannot work remotely does not automatically mean that those who are coming in get paid more. The same is true for if it's a group of employees who are home, not working remotely, and you have other employees who are working remotely. One group does not necessarily get additional pay just because their colleagues who might be in different positions or in the same position are not being required to do the same work or any work. I will say, however, that you need to make sure that the districts look at what their collective bargaining agreements say, particularly in the support staff realm. Many contracts have language that talks about, if a superintendent closes the school for emergency days, that those employees who stay home will still get paid, and the employees who come to work will get kind of an additional compensation because they had to come into work. And I think for those of you who have contracts that say that, it is really important that you get in touch with union leadership soon to talk about what that looks like moving forward, because those contracts, that language the intent of it was related to the 5 emergency days that we knew existed at the time. So you can bargain that language knowing that this is approximately how much it would cost me if I had to use it all 5 days. We are obviously in such a different situation now, especially with the likelihood of schools being closed for the remainder of the year. You are going to need certain employees to come in, and the idea of paying them more than their regular wage to do that when they're performing regular duties is obviously not going to be something the district from a budget perspective can handle. So making sure that you are talking as soon as possible with those unions about what that's going to look like moving forward, and bargaining it to the extent that you can as to what the 2 positions are.
Does the same apply for paying sub-consultants under contract, but not on the school's payroll? So like for social services, like hearing itinerants and psychologists and social workers, Nicki?
Yeah, so under the ISBE directive only applies to employees of the district. So not pursuant to the ISBE guidance, but you do need to look at your contract to determine whether you need to continue to pay under your contract or not. You also need to think about, long term, if you need access to those services once either school resumes or in some way throughout this process. So certainly your school psychologists, your social workers, if they're on contract, those are services you may need during this period. They may look a little bit different, so you may be sitting down with that vendor to figure that out. There may be contracts where you want to continue paying because you're going to need those folks up and running right when you return. I know that this has come up in the area of bus drivers. I know a lot of the bus companies in particular have been very proactive with our districts about trying to get continued pay. We have, many districts know we have sent out a vendor agreement addendum to address pay during this period. There may be some implications of the Stimulus Act if it passes on some of our districts related to vendor contracts and vendor pay. Certainly that's an issue that we're happy to discuss with individual districts should they need it. So again, no formal guidance that you need to look at your contract, consider what services, and then work through with the vendor with our assistance if needed to make sure that those services continue as you need them to.
Okay, we've got about 30 seconds left, so I'll ask one last question. Dana, how would we pay substitute teachers? We've heard a lot of questions about subs. What if they work in another district, for instance? What do we do with them?
I think Shelli answered the question about the subs that are or Shelli or Nicki, someone answered the question about the subs that are really just contracted by your district alone to cover a long-term leave, or they're like a cadre sub that they work in your district and they go to a different classroom every day. We're paying those people. In districts where you have a sub pool and you may share that pool with many other school districts in your area, and a sub may work one day in one district and another day in the next district. I think there's been two lines of thinking. You know, one is that they're not really covered under that ISBE guidance. They're not your employees. You know, they should not be getting paid. I think the other line of thinking, though, and I think anyone, I mean, I've talked to so many people this year. I know Shelli has, I know Nicki has, about what a sub shortage there is and how we're in crisis of not having enough people to sub, administrators going into classrooms to sub. So if you do have somebody that comes to your building but goes to other districts, they work one day a week and they have been, you know, working one day a week, and you anticipate that you might need them going forward, even if we're in e-learning, because we have to anticipate, even though it's depressing and hard to fathom, that some people may be sick and won't be able to perform their e-learning duties, and that we're going to need subs. Then you should really think and consider paying them that average pay, that one day a week going forward is a good option for your district.
Thank you so much, Dana, and thank you to all of our presenters, including Jennifer, who was having some technical difficulties, so dropped off. But thank you everyone for joining us. Please look for this on our website, along with all of the other thought leadership that we're putting out on the subject of coronavirus. And keep an eye out for an invitation next week. We will hopefully be doing this again at the same time in the coming weeks. So thank you again and have a great day.
Thanks, everybody.
Thank you.
Thanks, everybody.